Hello, everyone, and welcome to today's panel on how to build a privacy program for fast-moving companies. I am Sougol Shooshtarian, Corporate Associate at DLA Piper, Board Member of IABA Northern California, and it is my pleasure to co-moderate this panel today.
And I'm Sheila Esmaili, Principal of the Law Offices of Sheila Esmaili and Board Member of Iranian American Bar Association, the Los Angeles chapter. And I'm your other moderator for today. Two acronyms that you're going to need to be familiar with for today's program is California's CCPA, which stands for California Consumer Privacy Act, and Europe's GDPR, which stands for General Data Protection Regulation. Both of them have been recently enacted. First, Europe's GDPR, and now most recently, California's CCPA. Following California's recently enacted CCPA, California companies have been scrambling in order to get compliant first with the GDPR and now with CCPA. How does the GDPR and CCPA differ, and what do we need to know about the recently enacted CCPA? Today we have with us three experts in this developing legal field of data privacy who can help us unpack all of this stuff.
We're honored to introduce our guest panel speakers. I'll start with Chris Handman, is co-founder and COO at TerraTrue and former GC at SnapBank. Heather Antoine is, sorry, that's you, Sheila.
And Heather Antoine is Trademark and Privacy Partner at Stubbs, Alderton, and Markiles.
And Liz Eraker Palley is Senior Privacy Counsel at Google. Let's start off with introductions. Chris, we'd love to hear a little bit about you and your work at TerraTrue, a platform for privacy and security compliance workflows.
Yeah, no, great. Thank you so much. And I appreciate everybody taking the time to join us today. Look, for me, privacy, I came to it sort of by trial of fire. I was hired as Snap's first GC way back in the dark ages of 2014, long before GDPR was on the books. But Snap had, in its own inimitable way, managed to walk itself into an FTC consent decree for violating a host of privacy issues about 2 years into its existence. And as a result of this privacy consent decree with the FTC, they had to put together this massive privacy program that was going to be audited. And at the same time, that's what I had to do. Now, at that point, we had about 60 employees. We were shipping products at an incredibly rapid clip. And the last thing I was able to do would be go to Evan Spiegel and say, stop shipping products. We need to get privacy right. So for me, really building a privacy program for a fast-moving company was something that I learned from the ground up, learned as a matter of existential need at Snap. And we ended up doing something really successful. Fast forward a few years later, after the IPO, my co-founder, who was the CISO at Snap and spent a decade at Google, leading engineering and security, we realized that privacy was broken for a lot of companies. The increasing complexity and fragmentation of privacy laws, coupled with the ever-increasing speed of people shipping product, just felt like there needed to be a platform that could help scale those programs, bring automation, and bring a sense of consistency across teams that really unifies your product teams and your privacy teams. It kind of brings legal out of the silos. And so that's what we've built at TerraTrue. We've been doing it for 2 years now, working with some really exciting, great companies, and would love to be able to share, the experiences I've seen both at Snap and now what we've been seeing with companies out there in the real world.
Great, thank you, Chris. Heather, could you please introduce yourself and tell us a little bit more about your work?
Sure. Hi, everyone. I'm Heather Antoine. I'm a partner at Stubbs, Alderton, and Markiles. I'm chair of the Trademark and Brand Protection Practice, but more appropriate to why we're here today, I'm also co-chair of the Privacy and Data Security Practice Group, where I counsel companies of all different sizes and all different shapes, and really in every sort of industry that we have. In a lot of ways, we work with tech companies, but also non-tech companies in federal laws, which can range from, COPPA, the Children's Online Privacy Protection Act, to Gramm-Leach-Bliley, to state laws like the CCPA, which you guys mentioned, and Nevada and Maine's new privacy laws, as well as international laws such as the GDPR, which you guys mentioned, and other international laws like PIPEDA, which is in Canada. And really, I focus on figuring out the intersection of all of them and making them make sense, because otherwise it's just an alphabet soup of acronyms and various laws that treat things differently, different definitions of personal information, different requirements. And so what I really try to focus on is making sense of all of that and helping companies comply and figure out a program that works for them.
Awesome. Thank you, Heather. And Liz, could you please introduce yourself and tell us a bit about how you came to be Senior Privacy Counsel at Google?
Sure. Hi, everyone. I'm Liz Eraker Palley. So I took a bit of an unusual path in coming to Google, in that I joined the company straight after law school. I had previously worked there as a paralegal in California, and then had worked doing public policy work out in DC. And then in law school, did some other stuff, worked as a law clerk at the FTC and with House Energy and Commerce Committee, and a brief stint at a law firm. But coming out of school, had a pretty compelling opportunity to come back. And so initially was in DC doing privacy or policy counsel work in more of an external role, and then moved over to our privacy legal team about 8 years ago. And right now I do kind of a blend of things, super similar to kind of what Heather outlined, but from the in-house side. So it's a mix of regulatory work. So working with data protection authorities, DPAs on inquiries and investigations. Also do a lot of compliance work. So helping oversee internal compliance programs and making sure that they meet legal requirements. And then finally, a fair amount of privacy counseling. So working with our product lawyers, product counsel, to make sure that our products meet all legal requirements. So super interested and looking forward to talking more about it. Quick note that I'm here in my personal capacity, so not as an official Google representative. And big thank you to the IABA. This is a super timely topic, so great to have the discussion.
Great, thank you, Liz. A little bit about the structure of today's program. Sougol and I will run through today's topics with our 3 guest panelists, and we'll leave the last 10 minutes for a Q&A. There is a Q&A button at the bottom of this Zoom page. Just peek down there, you'll see it. Throughout the program, feel free to click on there and ask your questions, and Sougol and I will do our best to curate and present your questions to our awesome panelists to answer for you.
Thank you, Sheila. Okay, let's dive in. Currently, there are various privacy laws, as have been mentioned, that organizations need to comply with, including the European GDPR and California CCPA. Heather, we'll start with you. Can you tell us what the CCPA is, its relationship to the GDPR, and who the CCPA affects?
Yeah, yes, in short, I can do that. We could probably spend an entire month talking about that if you really wanted me to, but then again, this is my passion topic, so I'm happy to talk about it. The CCPA, the California Consumer Privacy Act, came into effect on January 1st of this year. It started being enforced on July 1st, so exactly 2 months ago today. So far, the Attorney General has sent out a number of warning letters. Under this act, the Attorney General will send out these letters, and you have 30 days to cure if you have an issue. Taking a step back as to how we got here, though, it's kind of an interesting history, actually. So there's McTaggart is his name. He's a real estate developer, a multimillionaire, and he was at a party and ended up talking to someone, I believe, from Google. And the person said, if you knew what we did, sorry, Liz, to call Google out on this, but on that meeting, he said, if you knew what Google had on people, you would be shocked. And so this real estate developer took it into his hands and said, he's going to put a proposition on the ballot. This was probably about 3 years ago now. That proposition was put on the ballot, and then the legislature convinced him to take it off the ballot if they passed a privacy law. That privacy law is the CCPA. It underwent a number of amendments over the last 2 years, the last of which was passed yesterday. And so it's under a constant review period, but basically, in essence, what it does is it provides consumers who are defined as California residents, any resident of California, the right to see their information and access it, the right to delete their information, the right to know if their information is being sold and tell people you are not allowed to sell my information, and the right to not be discriminated in the event you exercise any of those other rights. And that's kind of the CCPA in a nutshell. It was loosely based off the GDPR, which is EU's General Data Protection Regulation. I always tell clients that, if you're gonna get compliant with one, you may as well get compliant with the other. You're usually 80% of the way there, either direction. There are some differences, which, we can talk about later, but that's kind of a broad overview of the GDPR and the CCPA and how we've ended up here today.
Great, thank you, Heather. Chris, you built Snap's privacy program from the ground up when they were still known as Snapchat. And now as co-founder of TerraTrue, which builds an all-in-one privacy platform for companies, you've seen how companies of all sizes have approached these challenges. Are there common pain points that companies all face? And if so, how can they begin to build a privacy program early that won't feel overwhelming, but will also scale as they grow over time?
Yeah, no, that's, so I think the interesting thing being both at Snap and then now out in the market, working with a lot of great companies across the board, is the one common denominator you see, regardless of size. Maybe Google's a little bit different, although we'll see, is lawyers and privacy teams are just vastly outnumbered by developers and product teams. And that creates a lot of problems, I think, right there and then, with privacy laws becoming ever fragmented. I think Heather alluded to not just the CCPA, but there's a number of other states that have been getting in on this, and a lot of proposed legislation. Internationally, the GDPR, Brazil is another common target that companies are fearful of, but it sort of is spanning the globe. And while there's a lot of unifying principles around individual data, there's enough complexity and differentiation. And then, of course, every company's products are uniquely different and have their own idiosyncrasies. And so legal teams have a huge challenge keeping up with the flow of new products and understanding how all of those products map onto any number of different laws, the regulations they require, the different workflows or assessments or analyses they need to do, and then just keeping track of all of that data. Where is it going? What do they have to disclose? What third parties are going to be getting it? There's a number of long tails that really complicate that. And I think the one thing you see at all companies is the struggle among privacy and legal teams to really keep up with that pace. And the problem with that is there have been very few tools that companies have been using so far to kind of address that. I know at Snap, in our case, we basically built a privacy program on top of Google Sheets to try to just keep track of what was coming down the pike, and got to the point where we had 100 tabs and no one could open up the document during stand-up meetings because it was just getting too complex. And so that gets to your other question, Sheila, around scalability. You can start with a lot of modest tools. You can repurpose spreadsheets. The main thing you need to do early on is just understand what is being built by your teams, getting a good foothold on what is the data that your teams are going to develop. If you build a new registration flow for your mobile app, what are you going to be collecting? What sort of data is going into it? And how long are you planning to share it? And where are you going? I think those are the three big questions you kind of want to figure out. What data, where's it going to go? How are we sharing with it? And how long are we holding on to it? And I think just building some basic workflows that capture that, even if they don't scale initially, is a way of seeding that data into your systems, getting a good handle on what those workflows are, and then being able to maybe check those against whether those are templates or checklists or whatever you might have. And I think the problem with any of those tools, whether it's a checklist your outside counsel is giving you or a template that you have, is that again, it gets back to the pace. Fast moving companies, returning to the theme of this topic, are developing so quickly that you need to bring, I think, a sense of automation to that. You need to have some way of especially handling a lot of the repetitious type of data that you get over and over again. So to take one example, your teams might have a reg flow that is taking in username and password and device ID and a handful of data. And you might have all sorts of rules around it. And for CCPA purposes, say, look, this is coming from these various sources. The next time they go to build that, right now, it's at a lot of companies, if it's just on spreadsheets or some loose Google Doc or a Confluence doc, they're answering and asking and answering the same questions over and over again. And I think that leads to both like a fatigue among your product teams, but it also can just create a lot of inefficient problems with the scale. And so I think the main thing is to get tools to try to develop processes that harness the ways in which your teams have been working. That can promote consistency, it can promote reliability, and really ensure that you not only can scale faster, but you're sussing out those risks a lot easier. You understand what those flows are. So I think the main pain points that companies are facing is they're outnumbered. It's very manual. No one has really figured out how to really create that scale and automation. And if you can get rid of that manual aspects, if you can build in those processes, you can at least compensate for the sort of lack of proportionality between your legal and privacy teams to the product teams and development teams that are just shipping at usually ever faster rates.
Thank you, Chris. And that's helpful to know, I think, if people are listening and they're starting out with their own privacy programs and building those out in-house, it's like, where do you start and how do you keep track of everything? And if you're able to do it at the beginning, do it at the beginning. So Liz, similar to how Chris set out challenges for modern companies, working at Google, a company with a well-established privacy program, what do you think are the core components that companies should focus on?
Sure. So I think there's a lot of commonalities actually between the challenges that smaller companies face and also sort of larger companies, because of course as you get larger, you're building more products, you have more complex data flows, and so I share the sentiment of sometimes feeling, outnumbered by product and engineering teams. That happens a lot. So at a kind of 30,000 foot level, there's a few things I'd flag, and it really builds upon what Chris was talking about in terms of core components. So 3 Ps, starting with policies. I think, internal policies are a really important part of a successful privacy program. Putting these together, they're of course going to reflect, external rules and legal requirements, but then also internal standards and best practices. And I think that, these are a critical part of a program because they provide kind of rules of the road, a set of guideposts for, your product and engineering teams to know what they need to do. I think it's worth noting that they require a lot of time and investment to put together, particularly for larger, more complicated companies. But I think they're an essential building block for sort of other parts of the program. Second kind of P I would flag is strong processes, which Chris hit upon. I think the sort of core of a privacy program is your privacy review process. That's now a very clear requirement in the wake of GDPR. Privacy impact assessments, data protection impact assessments, as they're known under GDPR, are now legally required, but they're also just sort of essential to making sure that you're doing the right thing as you're launching products. A few things I'd flag around the privacy review process. One is just making sure that it's happening relatively early in the design process. So this is has been kind of a big focus of regulators. Privacy by default is kind of the term of art. under GDPR. But there's a lot of good reasons why making sure that you're starting early in terms of doing your privacy assessments is important. I think a second thing I'd flag is just making sure that this review process is supported by strong tools. So, you know, whether that's a external solution like TerraTrue or something you developed in-house, I don't think you can understate the importance of having workflows that actually, you know, make sense for your product and engineering teams, as sort of Chris hit upon, that allows them to, you know, proceed on track with their development, but also from a privacy standpoint, make sure that you're covering, you know, compliance issues. The privacy reviews are going to be multi-stakeholder, so making sure that you have right systems to, you know, pull in specialist teams as sort of needed, you know, whether that's your security team, folks that work on data access and auditing, making sure that all those sort of channels are working. And then the last thing I'd kind of flag with your privacy review process is making sure that, you know, you're documenting things, that you're in a strong position to meet, you know, what are increasing accountability requirements so that you can actually show the reviews that you've done and how you're mitigating privacy risks. Because we're increasingly seeing that that's something that, you know, regulators are interested in and leaning in on. The last kind of component that I would flag just is making sure that you're investing in your people. So I think that, you know, you also can't understate the importance of having, you know, privacy teams that, you know, have a strong technical background, that you're hiring the right people, and then that you're also doing ongoing training to support those people as they're doing their jobs. You know, that's important, I think, for making sure that you have, you know, that you're having teams that are going to work effectively with your product and engineering groups. And then I think training is just critical for support, and, you know, ongoing training. So it happens initially, but then on a repeat basis, so that, you know, teams feel supported and that you also are getting consistency in how you're kind of addressing requirements across products. Google's done a privacy and security month for, you know, many years now. It's just sort of one example of ongoing efforts to build awareness and share best practices. That's been pretty successful. So bottom line there is, yeah, making sure that that's routine.
Great, thank you so much, Liz. That was very informative. Heather, in your experience, what should companies do to assess their needs? When is the right time for someone to reach out to the legal department? What internal teams need to be involved?
Yeah, I think Liz mentioned some of this, which is, you know, assessing your need as you grow is really important, and continuing to assess that change. You know, legal, particularly with early stage companies, particularly when they're moving really fast to grow and develop, is kind of an afterthought. Not because, you know, people devalue legal, but mostly because when you're thinking about, should I spend money on developing this product or this platform or whatever it is, or should I spend money on a, you know, privacy team to do an evaluation? Let's build the product. Let's stand the product up. Let's build the service, put that out there, and then we'll deal with whatever happens next. And often for early stage companies and business owners in general, they're less risk averse than your general population. So they're willing to say, whatever happens, happens. So I always recommend we get involved as early as possible, knowing that most of the time, we're kind of going to be playing a little bit of catch up later if it's an early stage company. So as soon as possible, get to me. But when you get to someone like me or Chris or whoever it is, then it's really an impact of a question of, what do we have here? What is the world that we're dealing with? Data mapping is a part of the GDPR. It is not technically required by the CCPA, but I always have clients do it anyway, because you really need to know where all your data lives, who has access to it, who is it being shared with. All of that information really comes into play when you're building these privacy programs. And then it has to be adjusted every single time you grow. It's a living, breathing process. As far as who you want involved in this process, you want as many different teams as possible. Marketing is really important, and sometimes people forget about marketing. You want marketing there because they know what service providers they're working with, where they're pushing out ads, what data is being collected, how many consumers. Often I have to go to marketing to say, you know, how many consumers in California have we reached? How many consumers in the EU have we reached? They have that information, so they're really helpful to have on the table. You obviously need product and engineering there. You need IT because they know the flow of data. They know where things are being stored, how they're being stored. And then you need security because security is often important when you're talking about retention policies and how we're going to delete things. Now, in smaller companies, all of those are often combined, or maybe not all of them, maybe not marketing, but you'll have IT and security together, things like that. And then larger end, you'll have more of a spread out. But you need to have all of that information to have this privacy program be developed properly and to really assess the needs. Because sometimes what happens is, you know, the owner of a company will call me and say, hey, I'd like to move forward. And I'll start asking the owner questions, and they don't know. They don't know the answer to the questions. And frankly, it's not their job to know the answer to the question. You need to find the people who do know it and then build from there.
Great.
Thank you, Heather. Moving on a little slightly, Chris, like other compliance functions in a company, privacy is probably more than just knowing the rules. It's about creating a culture that understands the importance of getting it right. How important is that privacy culture when it comes to getting privacy right at modern companies? And what are the unique challenges that companies face when it comes to instilling that culture for privacy compliance?
Yeah, that's I think a really important variable because like as you said, with any compliance function, the culture is going to matter. The rules, of course, help, but unless you have buy-in from all of the right stakeholders and a recognition that this is something that we need to do as a matter of our corporate principles, it's going to be a porous, ineffective attempt to accomplish. And I think when it comes to privacy culture, you know, it has to be more than this idea that this is some bureaucratic box checking exercise. I think most companies who can do it effectively have people who understand that the goodwill of these companies, especially a lot of tech companies that interact with consumer data, you know, there's an increasing sense of a bit of a social contract between these companies and these consumers. And that's certainly what the CCPA and the GDPR reflect, is this notion that individuals have rights in their data and companies need to respect it. And I think you're beginning to see this cascading recognition among companies of all sizes and across all industries that respecting consumer data is not just something that the law imposes, but is something that actually enhances the products themselves. It can sidestep some unfortunate goodwill disasters down the road, like Facebook. And there can be some issues that, you know, that really help promote the way companies go about this. You know, going back to my earliest days at Snap, you know, it was somewhat easier to impose a culture when you're sitting under the gun of an FTC consent decree that you're going to get audited. You know, nothing focuses the mind like a potential company killing fine from the federal regulators. So, you know, I've always joked that if you're going to go under a consent decree, go on under it as early as possible in the company's life cycle, because you have an opportunity to set a culture early on. By the time, you know, we implemented those privacy reviews that Liz was talking about, which really are the lifeblood of making sure you're sussing out risks, not footfaulting your way into some problems, and really like developing that give and take that's essential. When we scaled, we had buy-in already. Like the heads of our VP of engineering was an enthusiastic supporter of this program we put together, in part because it promoted transparency, precisely those points we talked about. Everyone knows what's coming down the pike. Everyone has a sense of what's there and how the data is there, and everyone has a responsibility. And I think if you can empower people within your organization to take privacy as something more than just the sum of the regulatory parts, and to be something that helps you do your job better. Like we will now understand our data better. We can make better product decisions because we've mapped our data. We know where it's going. We can actually be smarter about that. And that has a lot of really great, important regulatory benefits, but it also really enhances the way we can serve customers, the way we can understand that data flows. And I think as you can round that out, it really helps you implement the processes that, look, and like any compliance process, there are going to be, there's some friction, right? The natural entropy is like those early days of like, let's just build and be heroes, and we'll worry about the regulations down the road that Heather was talking about. I mean, that's everyone goes through that. But at some point you need to start taking these things seriously. Whether it's because of the fine of financial penalties or just the worries of goodwill, or honestly competitive disadvantages. Increasingly you see, whether in the M&A context or whether in just doing work with other third parties, companies other companies, other purchasers, other contract parties worry about your privacy programs, worry about the data that you might be sharing with them and how careful as custodian you are of that data. And so having that culture becomes a competitive advantage. And so building those processes in place, putting all that rigor, I think you as a legal sort of kind of vanguard of the privacy movement can say, look, this is not just covering off our risks, it really is going to help us down the road. And that then just really gets the buy-in and I think team scale. But without that culture, it's really hard to do a lot of what we talked about. You're just basically going to be going through the motions, and going through the motions, you're going to end up missing a lot.
Thank you, Chris. I actually agree this move towards this more stringent data privacy is beneficial for all entities involved, and it's definitely a step in the right direction. My next question is going to be for Liz. In your experience, what are some of the easy ways that things can go wrong with privacy programs?
Sure. So a couple of things I wanted to flag. The first was just to say that I think building a strong culture is super important, as Chris outlined. And I think that connected to that is making sure that teams have the resources to actually support that culture. So I think first pitfall is, under-resourcing, which is a constant struggle, right? At your organization, privacy compliance might not be sort of, the first thing that product and eng want to spend money on. But, as we've talked through, there's a lot of reasons why it's super important. And so making sure that you're actually, bolstering the commitment to a privacy culture with the actual, tools and resources that teams need to get the work done, I think is really important. That you have both kind of top down and also bottom up support. And so that's investment, in internal tools and training, as we just talked about. Second thing I'd flag, and we've already, I think, hit upon this in a couple ways, is just the timing issue. So making sure that you're, that you're doing it early and not tacking it on too late, because I think that that's a common place where, things can go wrong. Looking at privacy issues after a launch is obviously the wrong time to do it. Third thing I'd flag, that's a pitfall, is the mindset that this is kind of a one and done thing. I think that there's a lot of focus around product launches at companies for good reason. But I think you also have to keep in mind that, particularly when it comes to legacy code, that issues can pop up down the road. And so having some review cycle to go back and look at those products, review data flows again, is really important. Same thing goes with, acquisitions. It may be a product that's already out there, but, doing reviews again as you're integrating those products into your systems is super important. I think that, privacy bugs just happen a lot with like legacy code, things break, et cetera. So something to keep in mind as you're designing a program. And then the last thing I'd flag is that you need to make sure that your products work as they're described to users. So basically that you're doing what you say you're doing to consumers. Given the complexity of products, the speed by which technology changes, the very rapid kind of launch cycles at a lot of technology companies, this is a real challenge, in terms of making sure that your disclosures are accurate and that your products and settings, work as intended, but it's critically important. And it continues to be a big focus of the FTC if you look at their enforcement cases under Section 5. You know, relatively sort of easy to spot, you know, just issues with explaining how things work can be a big problem. A few sort of things to sort of focus on. And I think, you know, they're as much of an issue for sort of big companies as smaller companies.
Thanks for sharing those, Liz. Switching a little in your experience, Heather, as outside counsel for your clients, what advice do you have for companies navigating the patchwork of privacy laws that apply around the world? We hear a lot about the GDPR and now the CCPA. Are there other privacy regimes that companies, particularly fast-growing companies with a global reach, should consider?
Yeah, so I want to take a second to just talk about why we talk about the GDPR and the CCPA so much. You know, when I first got into privacy work, I remember telling people, you know, you need a privacy policy on your website, and that was really the extent of it at that time. And people were shocked and horrified by the fact that I told them that they have to have this policy on their website. The GDPR was really the first massive regulation that affected people worldwide, because it affects anyone who collects data from EU residents. And that's most companies, when you think about the fact that, you know, we're all working in an international system right now. So when that took effect in May of 2018, it really did change the privacy landscape. And that's kind of what started us down this path. The CCPA obviously affects us because, one, we're in California, and two, it affects all California residents, and that's a huge population as well. And so anyone who's collecting now EU data or California data has to comply with these laws. And it doesn't matter where you're located. If you're collecting this data, you have to comply. So it's really a huge shift. And then what happened from you know, over the last several years is that we now have about, you know, 50, possibly even 100 different international laws to take into consideration. The big ones that people always talk about are the GDPR. You know, need to take into consideration Canada's privacy law, which is PIPEDA. It's the Personal Information Protection and Electronic Documents Act. You need to take into effect the new Brazilian law, which was just passed, the General Data Protection Law. That went into effect actually this month. It's modeled after the GDPR, so that's also helpful. A lot of these are modeled after the GDPR, but it has its own synchronicities. And so that has to be taken into effect when you're considering where your company and where, you know, as a fast growing company, as it grows, who are we affecting, right? Maybe we're not servicing anyone in Brazil when we start, but when we move into Brazil, or when we're considering moving into Brazil, that's the time to start working on that. You know, when we're going to move into Canada, then we need to work on that. So, because every move affects a different set of laws. And the one thing that I want to mention on this, which is, you know, kind of related, is, you know, what is next? And down the road here on the ballot in November, there is the CPRA. It's the CCPA 2.0. It's, you know, was put on the ballot by the same guy who put on the first ballot that I mentioned when we started, and this, you know, McTaggart is his name. And, you know, what it is intended to do is to bridge the gap between the CCPA and the GDPR. This is my personal opinion, not any other opinion, and I've already ranted about this on Twitter. I think this is a terrible, terrible thing at the moment. There's so many companies that do not have the budget to fully comply with all of the privacy laws that are currently in existence. A lot of people who are not even fully compliant with the CCPA. And so to add a new law that would change the definition of personal information, that adds different limitations to the way that data is collected, we're really making it nearly impossible for small businesses and mid-sized businesses to comply. You know, most businesses don't have a privacy team of 50 attorneys. They maybe have outside counsel, which has, there's a few of us working on it. And even that can get really pricey. So I personally think the solution here would be a federal law, although the odds of that happening are seemingly slim. But I will just make a note that potentially in November, we will have a new California privacy law added to this current regime.
Great, thank you, Heather. Thank you for getting us up to speed with these propositions that we should, take a closer look at. Now, my next question, I actually want to hear from each one of you. I will start with you, Chris. At a lot of companies, at least a lot of tech or tech adjacent companies, the legal and privacy teams are often vastly outnumbered by the product and development teams. What are some ways shorthanded legal teams can do to keep up?
Yeah, no, that it's a common affliction. And I think there are a few things that you can do. And the first really comes down to setting the right processes in place. Without a process that everyone can kind of buy into, the whole process breaks down. You need to understand who is responsible for, like, at that top of the funnel, understanding, okay, what is the data we're going to be using for this marketing campaign or this product that we're launching? And that's just very thin. So getting that process and then establishing who's going to be reviewing that. And then to get to Liz's point, making sure you can build those processes in as early as possible. The second thing, though, is you really do need some tool that amplifies the ability of legal to keep up. And again, TerraTrue, obviously, I don't want to have a shameless self-promotion here, but some tools that will at least capture what that data is that you're building, that can automate and flag, the risks in real time for your team, that can take structured data and understand, you are building using these 3 types of data, and you're sharing it with these 4 vendors, and therefore, you need to do these 3 things. And you need to have some way of bringing automation. I think this is one of the real frustrating aspects of working inside a company, is that there are so many technical tools that help bring scale and automation to every corner. Developers have Jira, product teams have Asana, everyone has that, but privacy remains this kind of fiefdom of siloed work, very manual, and nothing has really been developed. And I think the more you can bring tooling and automation that helps scale up those resources, that can help multiply your ability to process what's coming in and automate as much of those analyses and do the documentation as possible. Because a lot of things in privacy really are, it's important work, but a lot of it is leveraging past launches, iterating on top of those launches, and iterating on top of the analysis you've done before. So if you can harness that, repurpose all of that back into your data maps, your records of processing, if you have tools that can help seamlessly bring all that together into like one whole, then you are already going to be well in advance of any team that is sort of like struggling with the day-to-day, just let me look at it on a spreadsheet. So that to me is really developing your processes first, and then really trying to harness whatever tools you can to bring scale and automation.
Great, thank you. Liz, did you want to add to this?
Sure. So yeah, to build upon what Chris was saying, I think something else that I would flag in terms of ways that the importance of taking a risk-based approach. So FEMA has been the fast-moving space. There's tons of laws coming down the pipe, and I think it's important to make sure that your kind of approach is grounded in a risk assessment, that you're focusing limited compliance resources on the highest risk areas. And so that's going to mean looking at a number of different factors, but throw out a couple, the sensitivity of the data. So, focusing more review resources on products that might be processing types of data sets that have special protections under the law. You're also going to want to take a look at your enforcement risks based upon, your products and your sort of footprint. Where do you have offices in operation? So, if your service isn't available in South America, you don't have an office in Brazil, then You probably don't need to spend a lot of time, focused on, Brazil's new law, although, there is a lot of commonalities across all of these legal rules. And then one more thing I'd flag is the importance of building, strong relationships from the legal side with your product and engineering teams, and kind of investing the time to build those partnerships, educating them about sort of risks. I think that that's also a way to sort of leverage, limited resources, and something that you want to keep investing in. And then I think we've already talked a lot about the importance of taking approach, but you don't have to reinvent the wheel each time a new law comes down the pipe. There is a fair amount of overlap. I think GDPR is really the comprehensive framework that's put out there, and has that to kind of build upon as new laws come to play is really important. I know we did tremendous amount of in the lead up to GDPR, and we certainly weren't starting from scratch. We had a fairly mature approach, still seeing new requirements like CCPA come down, have been able to kind of leverage that prior work. So something else to keep in mind.
Great, thank you, Liz. Heather, did you have anything to add?
Only insofar as I want to kind of talk about the companies that don't have privacy teams, because the vast majority of companies don't, right? Most companies don't even have a general counsel. And so when we're looking at companies that maybe don't have general counsel or only have a general counsel or one or two, I really think the importance here of also leveraging one, systems like Chris and Liz have talked about. And then, like Chris and TerraTrue, is service providers are absolutely crucial here, because legal and your team are not going to be able to do everything on their own. It's painstaking unless you're able to automate and have a system for it. And then also leveraging outside counsel, because outside counsel can really flag, here are the high risk issues, right? Here's what we need to focus on first, and keep everyone on track. I often like to have weekly meetings with people as we're doing compliance, just to say, hey, have you guys done this? Have you guys done this? And it could be a 15-minute meeting, but at least we're keeping the team moving. And I think that's really important sometimes when you're dealing with smaller companies.
Great, thank you, Heather.
Thank you all. So that was the portion of our panel. We'd love to move on to the Q&A. And if you haven't already asked questions, please do so. The button's right at the bottom. You can type your questions, we'll field them, and we'll have our panelists answer. Sheila, do you mind starting us off?
Absolutely, we have great questions here. The very first question that someone submitted, I actually think maybe all three of you can answer. What advice do you have for young professionals starting out in this field? Liz, we can start with you.
Sure. So I just say at the outset that privacy is definitely a growth area. So there's just many opportunities right now in this space. So all of you that are in this space, you've chosen the right field. There's lots of job security. A couple of things I'd mention. One is in terms of making yourself marketable as a privacy professional. I think focusing on improving your technical skills is important. A lot of the compliance work that we've talked about today involves interfacing with product and engineering teams. We're having an understanding of the underlying technology is really important. And that doesn't mean that we all need to learn programming. But I do think having some fluency around the technology and data flows is really important to be able to do the legal and compliance analysis around issues presented by those flows. And then the second thing I'd flag is thinking hard about what role you want to play as you're looking for jobs, because there is a lot of variance in the types of jobs available in the privacy compliance field. So many of us on this call are attorneys, but there's a lot of compliance manager type roles that are super important. But the work that you're going to be doing there, implementing legal requirements, overseeing the operational aspects of a program is pretty different than the work that you might do as a privacy lawyer advising on legal risks. So think about how you want to use your skill set as you're looking for opportunities. And others might want to chime in.
Chris, did you want to add to that?
Yeah, I think the one thing I would say is that if you haven't already developed like a narrow focus on privacy, that's okay. I think so much of privacy is inseparable from just larger product counseling. And to be a good product, again, speaking of lawyers here, is I think having as aggressively generalist an approach to the law is really important, because at the end of the day, inside a company, whether it's a Google or anything else, you're unlikely to have an encyclopedic expertise across all ranges of products and all laws that it can implicate. But having a good sense of pattern recognition, a good ability to reason from first principles, draw on analogies from different regulatory contexts, is a way that gives you an ability to move incredibly quickly, be able to at least provide answers, or at least begin to suss out where those answers might be. And so as you think around kind of what you want to do, I would encourage people to not feel like you have to be like monomaniacally focused on the finer points of the CCPA regulations, but think again more broadly around privacy as a matter of these first principles and how it relates to a number of other fields and close cousins of privacy. And I think that will let you sort of really provide maximal value to your in-house clients.
Great, thank you. How about you, Heather? Any advice?
I guess the only advice I would be is to find someone who's doing what you want to do and reach out to them and talk to them and see. I know personally I ended up here in a very weird, twisty road, and it sounds like we've all, all three of us have ended up here maybe in a path that neither of us, none of us would have expected. So a lot of times there's pressure to follow a path, but also, be open and see who's out there who's doing what you're doing or what you want to do, and talk to them about it.
Thank you.
Great, thank you guys for the tips. I'll switch gears back to some privacy questions. This is for you, Heather, and I'd also like to know if Chris and Liz have opinions on this, but do you think we can become CCPA compliant without paying a law firm money? Do you think one?
Can you become CCPA compliant without paying a law firm money? Yeah, yes. I mean, if you want to put in enough of the research and the work to figure out what the regulations require and potentially how they're being interpreted, honestly, not by the AG, because they haven't really been interpreted yet by the AG other than the regulations, and there's probably more guidance to come. But the value that you get from hiring outside counsel is obviously that it's streamlined, and your risk pain points and what needs to be focused on is a little bit more carefully designated. But I mean, if someone really wanted to, sure, I think they can be. They could utilize service providers and learn the law and all of that.
Thank you. We have another question here. Are there certain practice areas in large law firm settings that prepare you better for in-house career in privacy law? So we went back to something related to my last question that I asked. So did you want to answer that, Heather?
Sure. I mean, I wouldn't.
Yeah.
I guess I'll open it up to anyone who wants to answer that, but.
Yeah, I meant Liz. So is there a certain practice area that would help prepare someone for an in-house career in privacy law?
Sure. So I think, obviously if you're doing privacy counseling at a law firm, in an outside counsel role, you're, helping clients deal with problems very similarly to how you do it when you're in-house, and that's great. But to Chris's point, I think that there's a lot to be said for just developing kind of your general toolkit of legal skills, strong analysis, understanding of like regulatory systems, and a lot of stuff that's, generally applicable, once you move in-house. So I know for, jobs as a product counsel or privacy counsel, and, here, and in both cases, you do a lot of privacy counseling. A lot of folks have, litigation backgrounds, weren't necessarily, maybe doing a little bit of privacy work in their law practice, but maybe not a ton. And, you know, I think that can set you up well for success. I think that there's a, you know, a lot of stuff that you obviously pick up, you know, on the job. And I think that anything you can do to sort of develop that general skill set is helpful. There's a lot of when you're in-house in terms of, you know, you're obviously have your legal hat on, but oftentimes you're advising on, you know, PR risks, you know, internal, you know, policy issues potentially. So, you know, anything you can do to kind of develop that skill set too, I think is valuable.
Thank you. Chris, did you want to add?
Yeah, I just want to say one grace note point I would maybe throw on there that actually loops back to the previous question that Heather answered around can you get away without hiring privacy or an outside counsel? And I think one of the answer I would say is you probably should, because you know, it's a matter of just they can do it a lot more efficiently and smarter. But it comes down to finding outside counsel who truly think like you do, in the sense, like, there's a lot, we all know there's lawyers who are going to know the rules, but you need, at a lot of these companies, you need someone who knows the rules but can calibrate risks with you. When you're in-house, you have no choice but to make those risk-calibrated adjustments that Liz was talking about earlier, right? Maybe you're going to just turn a blind eye to another country's laws because you just know there's just no way we're going to be exposed to that, and you can't keep up with it. So you're going to make that decision. And I think finding outside counsel who can understand the constraints you're under is really valuable as you build early on and invest your scarce resources. And I think that's incredibly wonderful to find. And then I think as applying it as a practitioner, never losing sight of your client's needs to harmonize legal compliance with the practicalities of the way they have to build their products and their constraints is an incredibly valuable tool set. And I do think, like, people from litigation see these trade-offs, but I think people from regulatory counseling backgrounds as well. And so again, in addition to rounding out your general toolkit and being just sort of intellectually curious around all these regimes, understanding risk calibration and what your clients actually face is probably the most valuable tool set as you begin to go into this increasingly kind of area of indeterminacy and privacy. And I think that's a really valuable tool set.
Thank you.
Thank you. Thanks, Chris. We'll just do one last question. And Heather, do you think compliance can ever be reached?
Probably not, honestly. That's the short answer. You know, compliance is a moving target, and yesterday was the last day of session for the California legislature, and they passed an amendment to the CCPA that frankly I'm happy they passed. It makes, you know, it extended the exemption, what is typically referred to as the B2B or, you know, employee exemption for another year. And that's really helpful for businesses trying to comply. But that's just one example of how, you know, every day is something new. And so you're kind of just continually playing compliance whack-a-mole, so to speak. And as you grow as well, the amount of compliance there, what laws you have to comply with change. So it's a game, and you're chasing it. But that's on the flip side, for those people who are willing to or want to get into privacy law, that's what makes it fun, is the fact that it's constantly changing, and the fact that it can be applied in so many different ways. So.
Thank you, Heather. And thank you, Chris and Liz, and for our attendees. And I hope we've answered some of your questions and thoughts that you've had about privacy programs. On behalf of the Iranian American Bar Association, we thank you for being here.
Thank you. We are a nonprofit organization. If you're interested in becoming a member, volunteer, or attending our events, check us out on IABA.us or reach out to us and we'll be happy to assist you. Thank you, everybody, and have a good day.
Thanks. Bye-bye.